The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon and welcome to the IIA Northern Virginia Chapter March virtual meeting on how internal audit can help drive privacy compliance. My name is Chris Miliaccio and I serve as the chapter's programs officer, and we were very pleased to have you as part of today's first ever virtual chapter meeting. We had a tremendous amount of interest in today's webinar with over 200 registrations, so super excited to have that. And I'd also like to thank Cross Country Consulting Team for making this program happen. So with that, I want to share some chapter news before we go into the program. The chapter's board and officer elections were supposed to take place this month, but due to the circumstances, we've postponed those elections. So we're looking at our options to either have them electronically or at a future in-person meeting. Now, for the upcoming April and May meetings, they're still being planned. For the April 21st meeting, we are planning to have another free virtual meeting from noon to 1:30, and we are working with our partner, Reputational, on the topic, disrupting the internal audit function and moving towards the next-gen internal audit. For the May 12th meeting, that'll more than likely be a virtual meeting as well. However, the topic for that meeting will be shedding light on the dark web, presented by RSM. So all this information will soon be posted on our chapter's website. So please just be on the lookout in the next few days, as well as us sending out announcements on that. Now, we are also planning a Chief Audit Executive virtual roundtable in April. So I know a lot of CAEs are wondering what other audit shops are doing during this pandemic. So this will be a great way of sharing that information. Also, the IIA has some great resources on the COVID-19 topic as well on their website. So I encourage you to check that out as well. The chapter is offering the CIA exam review virtual courses through Raven Global Training starting next month. So if you or a colleague, or if you know of a staff member wanting to become certified, this might be a good opportunity to prepare for the CIA exam. And registration is already open, so you can go to the chapter's website and register if you like. Some of this information, as I mentioned, is already posted, and we will be keeping everybody informed either through the website as well as sending out communications in our social postings on LinkedIn. Now, if you have any questions on today's webinar, please feel free to reach out to me. You see my email there on the screen. As far as the presentation slides, we will be sharing them on the chapter's website along with a link to this presentation. So it's going to be recorded for you, or if you know a colleague that wasn't able to attend, you'll be able to share with them as well. The chapter will be issuing the CPE certificates sometime next week. So just be patient with us on that, but that'll be coming through email to you. So with that, let me just go ahead and get started by introducing today's guest speakers from Cross Country Consulting. First, we have Elizabeth Kelly. She's a senior consultant. Elizabeth has experience leading a wide range of technology risks, cybersecurity, data privacy, and IT audit engagements. She's a certified Amazon Web Services professional and has extensive experience assessing security of cloud environments. Elizabeth is also a certified information privacy technologist and is passionate about utilizing technology to enhance maturity and sustainability of privacy programs. Next, we have Kenneth Riley. He's an experienced managing consultant. Kenneth is focused on helping organizations tackle the growing risks related to cybersecurity, privacy, and data protection. He has deep expertise in working with privacy and security offices to develop the people, process, and technologies to improve how sensitive data and critical infrastructure is protected. Kenneth is a certified information privacy technologist, certified information systems security professional, and a certified systems auditor. With that, I will turn that over to Kenneth.
Thanks, Chris. Really appreciate the introduction. And thank you to everyone who's dialed in. Really appreciate you taking some time out of your day to join us as we talk about privacy. I think in these uncertain times where we're all working from home or working remote, that can be a bit challenging. So it's really great to have a community of professionals come together talking about the topic. So hopefully you all have some lunch, some snacks, your drinks all ready to go, and we can go ahead and get started and get into the presentation and talk about privacy for the next hour and some change. Chris already talked about our introduction. So Chris, once again, thank you for that. Our contact information is also here if anyone has any questions after the presentation's over in the next, coming days, weeks, months, as we continue forward with privacy regulations, with COVID-19, with anything, feel free to reach out to Elizabeth or myself. We always welcome hearing from other professionals. Quick look at the agenda for today. So we're going to start out and talk about the history of privacy. Where did privacy come from? What's it been doing for the last, 30, 40 years? And then what's the current state of privacy? We hear a lot of buzzwords out there, GDPR, Ccpa. What else is on the frontier for us going ahead in the world of privacy? I don't think it'd be a privacy conversation in 2020 if we didn't spend some time talking about Ccpa. I think it's on a lot of people's minds as sort of the biggest and baddest privacy regulation in the US. So we're going to take a look at that both from how organizations and companies and businesses are responding to Ccpa, but also how us as consumers might be impacted by the regulation. Next, we're going to talk about how to build a privacy program. So considering all the regulations that are out there, how do we actually put in the protections and the processes and the technology around that regulation and actually protect data? We're going to talk about some of the privacy frameworks out there from NIST and ISO, and how you can actually drive compliance and innovation at the same time. And then last, and certainly not least, and I'm sure why many of you are here, we're going to talk about privacy risk assessment and privacy audit and how internal audit can actually be a huge champion for privacy and privacy compliance. So with that, let's take a quick look at the history of privacy. So we can go all the way back to Socrates and talk about sort of the theory of privacy and human identity, but I'll save you all of that and we'll start in 1974 with the Privacy Act. So this is really one of the first milestones in privacy, especially in the US. So the Code of Fair Information Practice was put out by the US government to basically establish a framework for the data that they were collecting and maintaining, and making sure that there were some protections around personal data. Flash forward a few years to the Federal Trade Commission's Fair Information Privacy Principles. So as you don't think about 1977 and really having the use of information systems, but the Federal Trade Commission really saw an increase in data being collected and stored virtually, and so they wanted to put together some privacy principles. There's not really a regulation behind this, but just sort of making sure that organizations have a framework they can fall back on to say, yep, when we collect data, we're going to use it fairly, we're going to protect it the way we would physical hard copy data, and we're going to retain it for only as long as we need. Jumping forward to 1998, as the internet is really starting to take off, you have the Cpi rule. This is really put into place to protect minors as they are browsing the internet. So making sure that websites are not advertising specifically to users of the internet who are under the age of 13, that they weren't targeting their advertisement at children who maybe didn't understand the implications of what they were doing on the web. 1999 is a milestone when we talk about industry regulations. So the Gramm-Leach-Bliley Act was passed, and a big part of the regulation is actually focused on competitiveness in the financial services industry, but they also include a fair number of information security and privacy principles in there as well. So this is ensuring that the financial data that we provide to the financial organizations, our personal data as well as our financial data is protected, and that there are controls in place over the systems that store that data, including some encryption and access security measures as well. 2016 is where we first really start to see some of these bilateral privacy agreements being put into place. So the EU-US Privacy Shield was put into place to protect the data that was flowing back and forth between consumers in the EU and the US and the businesses that were collecting their data. This is really putting a framework in place to say EU and the US both agree to certain principles on how that data is going to be protected and how it can be transferred back and forth between geographies. And that was really the precursor to GDPR. I think everyone on this call is probably very familiar with GDPR at this point. Passed in 2016 and finally put into place in 2018. This is really the most comprehensive privacy law on the books. When we are talking about sweeping regulations on how data can be collected and used, putting restrictions on how data can be transferred from one geography to the next, ensuring that there's specific contractual language in place between the collector of data and any third parties that they use to process it, and then also really expanding our rights as consumers to say, this data that you're holding, I'm going to allow you to hold it, but I want to restrict you from processing in this way, or eventually I may want that data back. I'll lump the next two together. Just 2017, 2018, we saw a lot of data breaches. We saw the Facebook Cambridge Analytical scandal, the Equifax breach. I think this is really where a lot of us started thinking about where is our data, who has our data, what happens if that data is breached, if a malicious actor were to capture that data, what's the damage that they could do to me personally. So I think this is all just sort of building up in all of our minds how important our data is and how important the trust that we put in organizations to protect that data. Last, certainly not least, but big topic today, Ccpa. So the California Consumer Protection Privacy Act was passed last year. It was effective as of January 1st this year with a fully enforceable date of July of 2020. So this is the biggest privacy law in the US, very, very similar to the GDPR in the controls that it requires from businesses, but also for the rights that we're granted as consumers. I think it would be an important topic to just bring up right now. I think it's really interesting in the time of COVID-19, sort of how important privacy is right now. We're starting to see HIPAA, for example, loosen some of their requirements around telehealth so that providers can actually meet with more patients without exposing themselves. We're starting to see countries like Israel using cell phone data to actually track and enforce social distancing and quarantine. You're starting to see companies actually gathering more healthcare data. And I think this is all positive right now in that we're helping to flatten that curve. We're helping to get data and information out there so that we can all be wise about what we're doing in response to COVID-19. But I think it'll be interesting, once we make it to the other side of this pandemic, all that data that's been collected, are they going to continue to put the right protections in place? Are they going to purge that data, or will they use it for their own purposes? And might that violate laws like Ccpa and GDPR? With that, I'll hand it over to Elizabeth to talk about privacy in the US.
Okay, awesome. Thanks, Kenneth. So now that we've walked through a timeline of privacy history in the US and also around the world, we wanted to take a minute to bring narrow our focus into the current US privacy landscape. So as Kenneth mentioned, we'll talk a lot about Ccpa today, but that's not to lose focus on the larger privacy landscape and what other state legislatures have been up to. So to kind of give you guys that view right now, we've provided this visual map. So the first states here that are highlighted are these purple states, and you'll notice it's the big hitters. So California, Nevada, Maine, and Washington, the ones we've heard in the news a lot recently. These are the states that have had privacy laws actually successfully passed. You'll notice that Washington has a little bit of a different pattern, and that's just to indicate that it's actually passed in its chamber or house of origin, but it's still moving through and being discussed and negotiated amongst committees in its non-originating chamber. So this next group of states, these green states that are appearing here, are kind of a step behind Washington, and that the privacy law is moving through the various committees of its originating chamber or house, but hasn't actually been passed yet. So Washington is considered one step further along than these green states. But the green states happen to be one step further along than these blue states, which represent states in which a privacy law may be just being introduced, or a task force has been created, but a solid draft hasn't yet been provided to committees to negotiate and deliberate on. So the key here is to understand that while there are still some gray states, privacy is definitely top of mind for a lot of state legislatures. And in the coming months and years, we should expect to see a lot more of these states hop on board and start to get shaded in. So in these next two slides, what we did is we took the map view, those states that were highlighted in the map, and listed them out here in a table, and filled in a little bit more detail about each regulation. And so on this slide, we can see the comparison between consumer rights like access and deletion, and the right to opt out, which we'll cover in a lot of detail later in the presentation. And then on the next following slide, we'll see key components of each of the privacy regulations are considering. Things like notice and transparency, data breach notifications, and security safeguards. The key that we want to drive home here is that while the consumer rights and key components may be consistent across both these slides and all these different states, each state application is slightly different. And you can tell that with all the different colored boxes that are graphed out here. This demonstrates the importance of constantly tracking each of these regulations and understanding how compliance and even internal audit teams can help understand how each regulation could apply to their organization. Another question this graph always brings up is the possibility of a national or federal regulation. We are continuing to track this, but there's still no major progress on this front. The two most recent federal regulations we've tracked were brought forward in November of last year. One was sponsored by the Senate Democrats and one by the Senate Republicans, but again, no major progress has been made as of yet. So now that we're kind of caught up on the current privacy landscape, I'll hand it back to Kenneth to talk about Cpi Fundamentals.
Thanks, Elizabeth. So absolutely, I think it's important for us to spend some time talking about the California Consumer Privacy Act. I think this really lays the foundation for US privacy law, and I think it can really help guide internal audit teams, compliance teams, legal teams who are starting to think about, what does privacy mean for our organization? What are the controls and the processes and the procedures and the technology that we're going to need to respond to privacy requests in going forward? So looking back just quickly, October 2017 is when Alistair McTaggart really introduced the first idea of the California Consumer Privacy Act via ballot initiative. It was passed and signed into law summer of 2018, went into effect as of January 1st this year, and becomes fully enforceable July 1st of 2020. There has been some conversation actually over the past couple weeks about COVID-19 potentially affecting that enforcement date. Nothing has been decided yet, but it's certainly something to keep track of. So the January 1st date is obviously important for a lot of reasons. I want to also point out that Ccpa also includes a 12-month look-back period. So this means that as a consumer, I would have the right to request any data collected from me, on me, all the way back to January 1st of 2019. So who's under the scope and applicability of Ccpa? So business is really the core concept around Ccpa. This is the organization that is ultimately responsible for the collection of data, of personal information. So Ccpa defines a business as for-profit, collects consumer personal information, determines the purpose and means of processing, and does business in California. Plus includes one of these, so revenue greater than $25 million, personal information, consumer households or devices, collected information more than 50,000 records, or an organization that specifically gains their revenue 50% or more from the collection, the sale, or disclosure of that personal information. So that's a pretty broad swath of organizations. You think about anyone who has an office in California, anyone with greater than $25 million revenue, or collects 50,000 records on consumers' households or devices. And the idea of the consumer. So this is the individuals for whom the data has been collected. and it is any natural person who is a resident of the state of California. That does not mean they have to be physically in California. You think about, for example, a college student who may be attending college in Boston, but they are from California. They would have the same rights under Ccpa as someone who is actually physically in the state within the borders. So Ccpa defines personal information as information that identifies, relates to, describes, is capable of being associated with, or could be reasonably linked directly or indirectly with a particular consumer or household. So the lawyers worked really, really hard on that one to make it, I think, as vague as possible. So this is talking about a whole bunch of data. I mean, anything that can be reasonably linked directly or indirectly with a particular consumer or household. I think even that household term has become a subject of some debate amongst lawyers and compliance teams and cybersecurity and privacy teams. So you think about, what does this actually mean? What are the types of data that might be under that definition? Obviously things like name, address, IP, email, social security number, driver's license, those are all the obvious. Those are the things I think we think about. But perhaps some commercial information. So your purchase history, or even the things that you didn't purchase, but they were in your cart on an e-commerce site, and data that's been collected and could be tied back to an individual account. Your browsing history, your search history, cookies, web beacons, things like that. Geolocation, biometric, educational or professional information, any sort of audio information or other electronic information that's been collected. And then this is the really tough area that I think some organizations are struggling with, that sort of data aggregation and automated intelligence, the inferences that are drawn from the hard data that you collect, the profiles that you might build about your consumers. Could that be reasonably linked or tied back to an individual? These are the sort of decisions and processes and things that organizations have to think through as they determine what is the scope of applicable Ccpa data. So what are some of the key roles within Ccpa? So we talked about this a little bit. Business, or as GDPR used to call it, the controller. This is the organization that is ultimately collecting and is responsible for personal data. So they are the one on the hook if anything were to ultimately, if data were to be breached, the business is the one who's going to be responsible. Consumer, or as GDPR called it, the data subject. So this is all of us. This is all of us as individuals, all of our households that are providing data to organizations for their use, for our benefit. The idea of a service provider, or as GDPR called it, a data processor. So this is the organization that's actually processing the information on behalf of the business. So the business collects the data, they provide it to a service provider. You think about ADP for payroll as an example. They're a big service provider when you think about privacy laws. So there's usually a contract in place. There's certainly usually some requirements that are in that contract that say, this is all under Ccpa. These are requirements that we're putting on you as a service provider. And then Ccpa also includes an interesting idea around third party. So this isn't specifically a service provider, although it could be inclusive of service providers, but essentially any other organization that may collect data that's being shared without a specific contract necessarily in place. So this may be like Google Analytics, which collects website traffic information. There may not be a specific contract in place on that kind of data collection, but it's certainly something for all of us on this call to be thinking about as privacy and audit professionals, but also as consumers, is what are all the fourth, fifth, sixth parties who receive our data through official means or in unofficial means. Really quickly, just want to talk about this. We've touched on it a little bit as we've gone through, sort of comparing GDPR and Ccpa. They both contain a lot of the similar language. You can clearly see Ccpa took GDPR as their template and built on it. So things like breach notification, privacy by design, consumer access to the data, portability, and the right to erasure or deletion. Also the private right of action. So if data were to be compromised or breached, consumers have the right to go back and request financial compensation and damages based on that breach. Now, where GDPR differs a little bit is they actually provide the right to correct data. Ccpa doesn't offer that sort of right for us to go in and request that our data be corrected. GDPR also requires a little bit more paperwork when it talks about data processor agreements, data protection impact assessments, records of processing, and then obviously those cross-border restrictions when you talk about data leaving the EU, certain restrictions being put on that. New in Ccpa from GDPR is the idea on restricting the sale of personal information. Now, the definition of sale is very vague, but we as consumers have the right to request that our data not leave the business, that it not go to any third parties. And then there are going to be protections for us against any sort of retaliation or different services provided by the business if we decide to exercise those rights. And then last but certainly not least, and we touched on this just a moment ago, but this idea of household data. So it's not just us as the individual whose data is being collected, but how can that data then be tied to the rest of your household? And so that certainly broadens the scope of data and certainly makes it a little more difficult to say, yes, this is personal data, and no, that is not personal data. So certainly another challenge for organizations going forward. Really quickly on this, obviously there are some penalties for non-compliance with Ccpa, especially if data were to be breached or exfiltrated in some way. It can come through private right of action from us as a consumer, and those fines can vary vast. And then there can also be injunctions and civil penalties that come from the California Attorney General, and those can be hefty if you think about each one of those adding up over time. I think it's also interesting here, and I think the internal audit teams here will appreciate this 30-day cure period that Ccpa includes. So after a breach has been identified, after they've sort of notified, there's this idea of taking 30 days to put mitigation plans in place. So making sure that you've got a plan to say, yes, data has been breached, but we're putting these plans in place to prevent it. We've got these controls. We were able to identify that some of the data was encrypted, and so it actually couldn't be read. So this really gives businesses the opportunity to respond to the breach, to put a plan in place to respond, and then also to make sure that they've got the right controls in place to respond. So with that, I'll hand it back over to Elizabeth to talk about some of the consumer rights of Ccpa.
Awesome. So having covered those fundamentals of Ccpa, we want to jump into the meat of the key principles and supporting requirements. So within Ccpa, there are several different requirements, and we've rolled them up into three broader, larger principles for understanding. So they're showing here on your screen now. The three that we are highlighting are control, so giving consumers power to manage their personal information; transparency, which refers to ensuring consumers clearly understand how their personal information is being used by companies; and then lastly, accountability, holding companies responsible for the security and misuse of that personal information. If we go down one level, we see these purple boxes, and they mostly, as I read through them, relate to the accountability principle. And they're likely covered in current internal audit plans. So meaning that they're processes that exist, that already likely exist at your organization, but may just need updated and reviewed as privacy regulations are passed. So if we go down one additional level to these blue boxes, these blue requirements cover the consumer rights. So these might be new rights that likely would need to be part of a privacy-specific audit or would need a new process implemented to cover. A lot of these might look familiar from GDPR if you spend a lot of time looking at GDPR, but things like the right to non-discrimination are unique to Ccpa. So what we want to do now is dig a little deeper into each of these consumer rights boxes. Try and click one more time. There we go. To discuss what processes may need implemented to meet each of these. Humor us a little bit here. We assigned these Sesame Street consumer rights champions to help you guys keep track and maybe smile a little bit during these uncertain times. We have our Cookie Monster, who's our right to opt out champion, Elmo, who's our right to non-discrimination, Count Von Count owns the right to notice, Big Bird owns the right to access, and Oscar the Grouch fittingly owns the right to deletion. And as we go through these, just kind of think about why, or humor us, and think about why we would assign each of these specific characters to each of the consumer rights. So the first right up here is owned by Cookie Monster, the right to opt out. And we wanted to quickly start with what a cookie is. And we've all interacted with these as consumers browsing the web. But simply put, a cookie is a small text file that's used to track your end user browser activities. Some cookies are certainly essential for the functionality of a website, but some may be extraneous. For example, cookies can be collected to deliver targeted ads or be shared with other processes to deliver you targeted ads. This is important to note because companies often sell, rent, release, etc., that information they collect from the cookies to other organizations. So that brings us to CCPA's opt-out requirement, which gives consumers the right to opt out of that sale of personal information. And you'll notice by the underlying definition, Ccpa's definition of sale is very broad. So it can include things like making available or transferring. So you can see that Cookie Monster is very clearly pointing to the inconspicuous button or link that's on the T-Mobile website, which is a requirement for companies to include. So California residents are able to request that their information not be sold outside of original use. So we also have a little comedy break there to bring a game of whack, a consent notification. So this is probably something you guys are also very familiar with seeing. As soon as you open a website, you'll notice a bunch of pop-ups and notifications with what cookies are being collected, which ones you can opt out of, sometimes even including please do not sell my personal information notifications. And while they may be annoying sometimes, they are all driven in part by regulations like Ccpa.
And then Elizabeth, just really quickly, I think this is another area where organizations that do business in the US as well as business in Europe may be struggling a little bit because Ccpa requires the explicit opt-out, whereas GDPR requires the explicit opt-in. So that makes consent even more difficult for cookies on a website when you've got to provide both of those options depending on where your consumers are coming from.
Definitely, good point. So we provided a little example here of what it might look like as a real world wacka notification example. So as we were browsing the Nike website, we were presented with the pop-up, yes, I accept the cookies that you're installing or tracking me with, or no, I want further information. And so we clicked, just an example of clicking that button for more information. It clearly lists the different types of cookies that Nike is collecting. You can see, as we mentioned, there are those functional cookies to deliver you the website and the platform that makes it easy to browse the website, but it also includes things like social media and advertising. So it's always good to be aware of what actually is included. Our next right, consumer right that we're going to cover is owned by Elmo, and it's the right to non-discrimination. So this is the consumer right that's unique to Ccpa, and it states that if a consumer opts out of the sale of personal information, so if they hit that, do not sell my personal information button we just showed, that Cookie Monster just showed us, a company cannot discriminate against them by providing or charging a different price or offering a lesser service. Companies still, however, can reserve the right to refuse service if the consumer doesn't provide the initial information required to provide the service at all. So let's say I reach out to T-Mobile and I want to open a phone line, but I don't want to give them my billing information or the other essential information that's required. They obviously can say, sorry, we cannot provide you with our service. Next is Count Von Count's right to notice. This states that businesses must inform all customers of pretty much any action that's related to their personal information. So this can include what categories of information they're collecting, the purpose they're collecting. So think back to the Nike website. They listed the purpose of all those cookies on their website. how they're collecting that personal information, and anytime they begin collecting new or different forms of information. So that last bullet we just talked about is oftentimes when you receive those email notifications saying, we've updated our privacy policy. And if you look at the brief email, it'll a lot of times include bullets saying, this is what we've noted, and these are the changes from our previous privacy policy and what we were collecting. Similarly, when you open your Facebook app, you get a push notification saying, here's what's changed, and here's what we now are collecting or not collecting. This consumer right ties really easily into that overarching key principle we talked about earlier of transparency. So the last two consumer rights we've combined as they go really hand in hand. The right to access, owned by Big Bird, states that companies must provide consumers the ability to request access to all personal information that's been collected on them in the past year. So businesses actually have 45 days to respond to those requests and provide that information accordingly. Kenneth will walk us through a real life example of what that looks like. Our team has had a lot of fun reaching out ever since January 1st, reaching out to various businesses and testing how they are doing this and if they are responding in the appropriate amount of days. The right to deletion, owned by Oscar the Grouch, similarly states that companies must provide consumers the ability to request deletion of all that personal information they've collected. So you can use Big Bird's right to access and request all of the information they've collected, and then you can use Oscar's right to deletion to say, okay, thanks for letting me know, please delete it all. There are certain exceptions that apply to this right, of course, for example, legal holds, and Kenneth will also go through the various different exceptions to that rule. But overall, definitely putting more control into the hands of consumers. So the processes behind providing these rights to consumers is a great opportunity for internal audit to get involved, perhaps through something like a tabletop session, where you walk through from start to finish how your organization would handle responding to a consumer access request or deletion request.
So with that, let's actually take a look at what this, how this might work in the real world. So as Elizabeth mentioned, our team, because we live, eat, and breathe this, has been testing out various organizations' capabilities to respond to privacy requests under Ccpa. I think it's been really interesting to see all the responses, especially since none of us live in California. We're requesting these from Virginia, actually, and so organizations, a few of them have come back and said, we don't list you as a California resident, so we're not going to respond. Some just haven't responded at all. However, I put in a request to Chick-fil-A, and they responded back about 38 days later with a password and with this encrypted information, which listed all of the data that they had collected from me, including my name and my birthday, my email address, and my phone number, as well as the one time that I complained about my Chick-fil-A sandwich not being through the mobile system. So they really were responsive in letting me know what data they had. And I found it especially interesting given that technically I don't have this right under, there's not a Virginia law. They were still responding, so it seems like they aren't necessarily making a differentiation between residents of California and others, which we're actually seeing a lot of organizations say, it's going to take us more effort to figure out who's from California and who's not. It's just easier for us to provide this sort of information back to anyone who requested it. I have not requested that Chick-fil-A delete my data because I still plan on using their app and making Chick-fil-A sandwiches a regular part of my diet. So as Elizabeth alluded to, there are some exemptions to these requirements. There's some ways that Chick-fil-A, as an example, could have responded back saying, no, we can't provide that data, or especially we can't delete that data because XYZ reason. So one of those may be transactional. So you think about some data integrity issues or ongoing transactions with an organization. For example, I can't request that my bank delete my information because my account, I want my account to stay active. So there's certain data that they need to hold on to keep my account active. You can respond back with saying that we need to keep certain data for security reasons. You know, this is part of our logs. We need this for incident response, breach, you know, notifications, different things like that. So you think about security data being an exemption. Legal obligations. So you think about, you know, certain, you know, legal holds that may exist through, you know, court filings or things like that. You know, you think about some of the regulatory requirements that might exist. You know, if you've got to hold on to certain data for SEC filings, that data can't be deleted for, you know, whatever retention period that organization has placed on that kind of data. You know, that is an exemption under Ccpa, and that's not data that you have to necessarily delete if there's a reason to hold on to it. System functionality, this one's a little more vague. You know, I think this one might be a little harder to defend in court if it ever came to that, but if there's data that you need to keep your systems up and running, obviously the law is not going to, you know, have you break your information systems to respond to a consumer request. Research in the public interest. So this one's actually coming up a lot right now, especially around COVID-19. And while public interest can be a little bit hard to define, you know, you really have to go out of your way to prove that the data that you're collecting is going to be returned back to the public for their own good. You know, any sort of, you think about research studies in universities or government agencies, like the data the Census Bureau is collecting, you know, data like that might be important to hold on to. Expected internal and lawful uses. Once again, this might be a little more difficult to defend in court if it comes down to it, but this is sort of a catch-all for saying this data is essential to our business. You know, we cannot continue as an organization without this data. It is paramount to our success in an organization. We will not exist in the future without it. Data around free speech. So, you know, any data that you're putting out there that's sort of under the auspice of free speech, you do not have to delete. And then last but certainly not least, Cpi compliance. So this is the Electronic Consumer Privacy Act in California. So if there's certain data that you need to hold on to prove compliance with that law, you know, you think about some of the other laws as well. GLBA, there's a specific carve out in Ccpa for financial data protected under GLBA. So there's certainly some regulatory compliance carve outs, data that you would not have to delete if a consumer requested. I think one thing to keep in mind with all of this is that all these exemptions need to be justified. So you need to go through and think about with your organization what data might fall under one of these exemptions. Think about all the personal data that's been collected, and then start to sort of section off what data could we delete if it's been requested, and then what data do we absolutely have to hold on to that would fit in one of these buckets.
So next, we're going to talk a little bit about building a privacy program and what that might look like from a more responsive approach to regulations to a more proactive and sustainable approach. So we've mapped out sort of milestones to compliance, and the roadmap we're about to go through right now is specific to Ccpa. That's not to say as more regulations are passed, you can't take steps in and out and adjust for new regulations as they come about. So starting with applicability, which is understanding whether or not the regulation actually applies to your organization. So as we talked about earlier, only certain businesses actually fall under Ccpa or have to comply with Ccpa, and similarly, only certain consumers are protected by Ccpa. From an internal audit lens, this relates really well to having a strong scoping process in place. Next is data mapping, so understanding how personal data flows throughout systems and teams in your organization. We'll talk about the data lifecycle a little bit more later, but understanding, you know, from external sources to internal sources and exchanging hands throughout teams, being able to track and map that in a consistent way is super important. So this is where really strong data governance controls come into play. Next, vendor contract updates. So understanding how vendor or service provider contracts may need updated to comply with the new regulation. For example, does a data processing addendum need added? Does some of the other paperwork that Kenneth talked about earlier need added? This may include looking at and improving your vendor risk management process as a whole. Next is working through the processes that need implemented or improved to cover the consumer rights we walked through. So thinking about the specific ones with each regulation, things like access, deletion, and the right to non-discrimination we talked about. Next, looking at your privacy policy updates, so ensuring that both your external and internal privacy policy and external notice contain all the necessary clauses that the regulation requires. This goes really well, kind of hand in hand with reviewing any security procedures and processes you have in place, reviewing the technical safeguards you have already, and ensuring they meet regulation standards. So this is something as internal audit we are very familiar with and are used to kind of reviewing and updating as needed. This next one, incentives, there's a little bit of back and forth on what it means and how it might conflict or relate to the right to non-discrimination. But essentially, this step, very specific to Ccpa, ensuring that there's a strategy in place for disclosing any financial incentives offered for consumers that share personal information. And you may be thinking, wait, that sounds like they're discriminating against certain consumers who are enacting their right to non-discrimination. But a good example to easily demonstrate this is a grocery store, let's say Safeway, which I'm sure we're all members of their loyalty program. They offer, as a part of that program, certain coupons and discounts to us who provide certain basic personal information, like a phone number. I know when I check out, I type in my phone number at the end, and I get all these great discounts. I then submit a request to opt out of the sale of that personal information, and as a result, I get removed from the loyalty program, and so I no longer get those discounts. That act of removing me because I requested to opt out of the sale of my personal information is considered discriminatory, but it's not unless the grocery store. It's not if the grocery store can demonstrate that the value of the coupons they offer me and the discounts they offer me are reasonably related or equal to the discounts that I get, or the value of my data to the business. So a little tricky there, but essentially this step is we included this step in the roadmap to show there are going to be nuances with every regulation and things you'll have to think about. So this one is about creating a strategy for this certain thing and for offering incentives. And last, but certainly not least, arguably the most important step is training and informing employees on any new requirements that might have been implemented as a part of compliance with the regulation. We've pulled out some example approaches from three of those roadmaps for you here. The first one, security procedures, just giving some ideas of what security policies or processes might need updated as a part of a regulation, including encryption, logging and monitoring, definitely data destruction, et cetera. Next one, privacy policy updates. So yes, we know we might need to look at the privacy policy and update it accordingly. Some supporting standard operating procedures that might need to be added to help with that are things around the do not sell my personal information, cookie management, and privacy incident response. And then lastly, some examples for what actions in implementing processes for handling consumers' requests might look like. It could include performing an analysis of current tools and capabilities you have to be able to manage these consumer requests. It could also include implementing a privacy program software solution, such as OneTrust or TrustArc. So using that technology, which we'll talk about a little bit more in a minute, to help drive that compliance.
So, and I think it becomes very clear here how internal audit can start to become a huge champion for privacy in your organizations. Obviously, internal audit teams have an incredible background of not only the technical controls, but also you talk about the business processes and the systems involved and where is data being collected and how is that data flowing through the organization, the process flows that you might have already developed or data maps that you might have from previous years' assessments. So it just becomes very clear how important internal audit is going to be in sort of building out a privacy program and bringing along all of that institutional knowledge that you've developed over the years.
Absolutely. So now that we've covered a roadmap for a more responsive to regulation approach to privacy compliance, we wanted to introduce two recently developed privacy frameworks released by institutions as either current or previous internal auditors we all know and love, ISO and NIST. We won't go through these two slides in a lot of detail, but the thought behind implementing one of these frameworks is to really help your organization move from that responsive approach to a more proactive and sustainable compliance approach. So starting with ISO here, if you're an ISO shop, it's easy to just tack on these additional privacy framework controls. So it's not to say that just because you implement one of these frameworks, tracking individual regulations and ensuring you comply with specific nuances of each regulation becomes obsolete. But having these foundational frameworks certainly help to ensure compliance with new regulations will be a lot less painful. So looking at NIST here, just to kind of drive home the fact that these are add-ons to existing NIST and ISO frameworks. The NIST, you can see on the left here of this table, the NIST functions are very similar to, the NIST privacy functions are very similar to the NIST cybersecurity functions. So you'll even notice that identify, protect, and respond are consistent. We add a little bit more detail on privacy, control, and inform domains. Another interesting note on the NIST front is that a lot of you may be tracking the NIST 853 fifth revision. I believe a final draft was just released very recently for comments that I believe are due in May. But it actually includes an entire new control family for PII processing and transparency. So that's a really good example of demonstrating that privacy is definitely top of mind for a lot of these organizations, and there continues to be more and more guidance released for organizations attempting to implement a more sustainable privacy program. So quick pause just to kind of get an idea of where a lot of you are sitting. So we're not going to unmute lines or anything at this point, but we invite you to raise your virtual hand just to get us an idea of how many of your organizations have either utilized a standardized privacy framework or designed their own.
Great, starting to see some responses come in. Yeah, I mean, I think Elizabeth, as you alluded to, it's really interesting, and I think it's telling that both ISO and NIST decided not to put out a brand new framework, but to take the existing cybersecurity frameworks and the IT frameworks that we're familiar with and add on the privacy requirements. I think obviously, you know, in today's day and age, you know, when you talk about digital privacy, you know, taking those existing security controls around encryption and access management and change control, vendor risk management, supply chain management, you know, it only makes sense to put the privacy lens on those same controls rather than designing something from scratch. And we'll talk about more of that sort of technical implementation here in a minute. But yeah, thank you everyone for who responded. We appreciate that. Okay, so obviously we spent a lot of time talking about the compliance challenges with CCPA, the legal and the regulatory challenges that you might face. But I think along with those come some certain technical challenges. You know, when you actually get down into the weeds and you start taking a look at what systems we have data in and how is that flowing across our organization, there's a few other things to consider. So we just wanted to highlight those quickly. First is around even identifying data. So if you don't have a good system to classify and map and tag data, figuring out where you're storing personal information, figuring out where that data has traversed the organization is going to be a challenge. You know, we're talking about a day and age where data proliferation is massive. You know, we're talking about interconnected systems, not only on-prem, but in the cloud. And then you talk about bringing in your third parties. You know, your data is everywhere. And so that's something that's going to be a bit difficult to track down and just make sure that, for example, if you received a data subject access request, are you confident that you know the dozens of places where that data is stored? And there isn't a disconnected system somewhere that's perhaps storing some really sensitive data that you're unaware of. This also extends to your data archives and backups. And you start to think about if you've got all this data stored in Iron Mountain, for example. If you got a data deletion request, could you go back and actually make sure that data that's been stored is compliant with the regulation as well? Data accuracy becomes really, really important. Managing all of your disparate systems, whether you've got them central managed or they're managed on their own. How do you ensure that if someone were to put in a request to update their data through GDPR, that you're hitting all those different systems, that cascading effect is in place? This is also really important when you think about disaster recovery. If you have updated in your live system, that system goes down, you're now restoring from archive, and that contains outdated data. How do you handle that? Obviously, data security becomes a bigger issue and more and more important for all of us. So making sure that your data at rest and in transit is protected, making sure that you're putting the right levels of encryption on your data, that your systems can handle that encryption. Potentially starting to talk about tokenization. That's becoming a hot topic, or perhaps even field level or record level protections rather than encrypting the whole database. Are there specific fields that you encrypt versus the entire record? And then also, touch on tokenization here, but you also talk about pseudonymizing or anonymizing data and potentially using that as a protection method so that you're not exposing, an actual individual social security number to a third party, but maybe just an identifier that actually isn't linked back to them. This is sort of touched on in all of these other different areas, but just the ability to delete data. It's one thing to say, yeah, we've got a process, we can go and identify where the data is, but how confident are you that you can delete data upon request? How confident are you that you can delete it in all of the right places and make sure that there aren't going to be any cascading effects, that it's not going to affect any of your interconnected systems and reduce your functionality. And then last, but certainly not least, because I think it's part of every other topic that we've touched on today, but how do you ensure that your vendors have the right security and privacy controls? What contracts do you have in place? Do you have the ability to audit? Are you ensuring that when you are transferring data outside of your organization to that third party, that it's encrypted along the way and that they aren't then exposing it to a fourth, fifth, sixth party? And so I think it's really important as we talk about all of those challenges to remember that there's not going to be a single solution to mitigate all these risks. There's no silver bullet. There's no button that you press and all of a sudden all of your privacy concerns go away. It's really going to be a layered approach, a defense in depth approach, where at the network layer all the way through to your data layer, hitting your clients and your apps and everything in between, that you're putting the right protections on each layer. So we talked about, for example, anonymizing your data as much as possible. Any field level encryption, making sure that your classification system is strong and that you're actually using it. So going to your app teams and saying, hey, we need you to make sure that you're classifying that correctly, that that's personal information, that's confidential, or that's public. At your network layer, do you have the right encryption protocols in place over data in transit? Are you authenticating machines on the network properly? Do you have monitoring and logging in place over network traffic? Do you have DLP on your endpoints? Are you able to identify if data is being exfiltrated and a breach is in process, or are you only going to find about that later? So I don't think we're introducing any necessarily new topics here. These are things that information security and IT teams have been talking about for years, but it's now putting that slightly different lens on it, a nuance, if you will, focused on privacy, focusing on specific personal data, putting perhaps some additional protections in place, investing in some new technologies, and then also making sure that your compliance teams, your legal teams, your privacy teams are aware of the protections in place so that they can respond to these regulations appropriately. So how might technology enable the privacy program and the privacy build process? So at the top here, we've got the compliance roadmap that Elizabeth talked about earlier. So I just want to touch on a few of the different areas and perhaps how technology can be used to strengthen a privacy program. The first one we'll talk about here is the ability to map and tag data. This can be a really arduous process. This can require a ton of manual hours. I know Elizabeth can talk to this personally. The ability to identify data and data elements and build out your data element library and say, yep, we collected it in system A, but it's eventually getting to system Z and all the stops along the way. So you're going to see systems start to come out and technologies and platforms such as OneTouch or Calibra, which help make this process a little easier. Obviously, you want to make sure that the source data is good there. You want to be able to rely on these data maps for decision making. Just the ability to put some of these workflows in place to design these data maps is going to be a huge relief for everyone. Next section we'll talk about here is just the program itself. How do you sort of demonstrate compliance? How do you respond to a data subject request? How do you make sure that you're tracking consent accurately? How do you make sure that all of your privacy policies stay up to date? So this is where a sort of suite of tools and modules can come together and you can have an all-in-one privacy platform. We'll talk about OneTrust specifically here in a second. You also see things like TrustArc, a few others out there that are sort of providing a one-stop shop for privacy programs to respond to data subject requests, to build your data inventory, to build your vendor program, and sort of manage all your contracts and your data processing agreements. So I think it's really important to sort of have that one place you can turn and say, here's all of our privacy information. And then the last one here, not necessarily new technologies, but once again, making sure that you've got those existing security controls in place and that they've been finely tuned to the right level for the new privacy regulations, for the new data that's been in scope, that you're using functions like secure computing, for example, or confidential computing to reduce the amount of data that needs to be exposed to an organization like Azure or AWS for their processing purposes, so that you can still, for example, encrypt your data in the cloud and not restrict yourself from some of the functionality of the cloud, but still have that confidence that you're protecting personal data. Real quickly, just want to touch on some of the tech that we're seeing out there, some of the organizations that we started having conversations with across country about their capabilities around privacy. OneTrust is a big one. I mean, if you're on sort of any privacy email distro, if you are a member of the IAPP, OneTrust is a great organization that provides, once again, full, almost GRC-like solution for privacy. So it's going to cover consent, it's going to cover training, it's going to cover some of the vendor risk. So really great organization, definitely one to check out. Next one we'll touch on here, Audit Board. So I'm sure many of our internal audit team members are probably familiar with this sort of tool. So it's a great sort of audit program building capability, lots of control libraries existing in there. So if you're sort of starting from scratch saying, how do we assess privacy? How do we assess some of these security controls? Audit Board might be a great tool to turn to sort of help you give something so you're not starting from scratch. And then last but certainly not least is an interesting tool out there that's actually network layer packet inspection. So taking a look at metadata and actually automatically building out your data map. So whereas it maybe is a manual process for a lot of organizations to meet with their business functions, to meet with their app teams, build out that data library and sort of map it all across the organization. A tool like OneTouch actually takes a lot of that manual effort out and can actually build you a data map showing where data elements flow from point A to point B, from endpoint to database to, outbound network traffic. So another interesting tool. I think we're going to see a lot of growth in this space because it's just so important to know where your data is and how it's flowing through your organization. So another poll the audience here quickly. So if anyone wanted to sort of raise their hand, if they've started down the path of implementing a privacy tool like OneTrust or TrustArc or any of the other tools that we just mentioned, I just want to sort of see where everyone is in their privacy program maturity. Awesome. Starting to see some responses. Thank you for that. Glad everyone's still paying attention. Certainly welcome any questions at the end here. If anyone has any specific questions on privacy platforms or technologies, feel free to let us know. So obviously, what we're all here for is how internal audit can help drive Ccpa compliance. We think internal audit has a pivotal role in not only helping getting to a state of compliance, but also monitoring and keeping the privacy program up to date for the long run. So we think there's a natural partnership between the internal audit function and the privacy office. Now, we recognize not every organization is going to have a privacy office. This might be a new function. It might be your compliance officer or your general counsel taking on a new role. But hopefully someone in your organization has some knowledge, is tracking these regulations, is aware of some of the requirements. And then internal audit can come alongside them and say, okay, we understand the requirements. Here's what we're doing already to meet those. Here are the processes, the procedures, the technologies we already have in place to respond. And so from there, how do you actually build a privacy audit? Many organizations are probably looking at 2020, 2021, thinking, this is a big deal. We need to understand our risk posture. We need to understand how our privacy program can respond. And so it's a pretty straightforward process. I think everyone's going to be familiar with the basic building blocks of performing a risk assessment, actually testing controls, and then doing your ongoing monitoring. But it's really making sure that you're considering privacy risk specifically, utilizing specific privacy frameworks like NIST or ISO, and then relying on technologies that have been built to consider data and personal information.
Awesome. So as most of us have been or are currently part of internal audit teams, we can all definitely understand and appreciate the importance of performing a business or security risk assessment. And a lot of us have probably actually performed them ourselves. Similarly, performing a privacy risk assessment can be a really good way to gain understanding of privacy risks that may exist and any gaps that need remediated in your privacy processes. Like any good risk assessment, this of course starts with a strong scoping phase, which can include things like understanding your data lifecycle from start to finish, understanding any regulatory requirements, and understanding if there are any specific vendor agreements or data processors that you're working a lot with. So I want to introduce this idea of a privacy risk universe, and this can kind of help drive your privacy risk assessment in different areas you can start to look at. It's definitely not meant to be an all-inclusive or exhaustive list, but more just ideas to help you map out some of the areas you can start to think about including in your privacy risk assessment. So starting with privacy policy, review, technical safeguards, data governance, and operational security and privacy by design, breach detection, response, looking at vendor risk management program. A lot of these things, as you read through them, you'll notice that they're very similar and sound familiar from the Ccpa requirements and clauses we just walked through earlier. So just using this slide as kind of building blocks to start to build out and understand where your biggest privacy risks might lie. And then once we have our risk assessment scoped and mapped out, it's obviously important to consider how we're going to assess and measure risk in each of these areas. So being able to measure likelihood and impact of privacy risks is key to be able to prioritize risks for remediation. So we've listed here on the right of the screen some factors that can be looked at and used to assess that likelihood and impact. So including things like the current formality of your governance structure, any known privacy or security incidents that might affect your processes, regulatory compliance implications, of course, implementation of privacy-focused technology, etc. And then finally, this slide is supposed to serve as an example of how you could map those privacy risks using those measures of impact and likelihood of occurrence. So we use it to create a simple heat map so we can easily visualize and see what areas need the most attention and where our biggest privacy gaps lie.
I'm just going to go back here just for a quick second. Obviously, the names, this has been scrubbed of any sort of names or client names to protect the innocent. But I think these are actually some real risks that we're seeing out there, and pretty accurate and representative of at least my experience working with some of the privacy teams who are struggling with privacy by design, and how do you actually implement privacy from the very beginning of your application development process to your systems acquisition process. Teams are lacking in skills and training. They don't have the expertise around privacy yet because it's a new field. And then areas like data access management and secure disposal. These are certainly new topics introduced by Ccpa, and so organizations are struggling to put the processes in place to respond if they were to get a data subject access request. So once you've done your risk assessment, you've identified where some of your key privacy risks are. It's obviously now time to move that into the audit plan. So we want to just touch on a few potential audits to consider, areas where you've seen some higher risks for privacy teams and for internal audit teams to consider. So the first one's a data processor review or a vendor review. So taking a look at those organizations where you share data externally, making sure that they have the right agreements and contract language in place to protect data that's being shared, making sure that there's coordination on incident and breach management, and generally just making sure that they've got the right IT and security controls, that you actually can obtain evidence that they're encrypting data, that they're putting access management controls in place, that they're not continuing to share that data outside of what's stated in the agreement, and that they're not using it for any additional purposes other than that's been stated in the contract and communicated to the consumer. Another one is taking a look at the data lifecycle as a whole. So making sure that you're scoping your high-risk data and you have an understanding of how that data is being collected and how it's being used all the way through to retirement. So making sure that your sensitive data is sort of being protected all along the way, and that it's eventually being put in a place, it's being deleted, it's being archived, it's being anonymized appropriately in accordance with your data retention schedule. And then last is a simple controls maturity assessment. So thinking about some of the requirements that we've touched on from Ccpa, thinking about your NIST or your ISO frameworks. Do you have the right controls in place? Are they mature enough to respond to the privacy regulations as they are stated today? This is inclusive encryption, access management, change control. Do you have the right policy and documentation in place? Do you have the right people? Do you have the right roles and responsibilities defined? Does your privacy team include compliance and legal and security? So lots of different ways to come about this, but essentially getting to the core of how do we respond to a privacy request? How do we build a privacy program? How are we responsive to future privacy regulations that are certainly going to be coming down our way? So I wanted to just quickly, I know we're getting close on time here, but quickly touch on a few of the other potential data protection and privacy regulations. Obviously, we've spent a lot of time talking about Ccpa and GDPR, but I'm sure there are plenty of organizations out there that are thinking, what about HIPAA? What about GLBA? What about PCI? Obviously, each one of these regulations has specific data protection requirements, making sure that you're protecting healthcare data, making sure that your financial data is protected, making sure that credit card information is protected, and that you've got the requirements in place around penetration testing and vulnerability scanning and all of those different requirements. So just other things for you to think about, depending on the kind of data that your organization collects. These are other areas, other regulations for you to turn to build out your privacy audit program and considerations for your testing of controls over data. A couple other things to consider here as well is the insurance industry is actually moving forward with putting together its own data security and cybersecurity requirements. Right now, these are sort of moving state by state. So just something else for you to track if you happen to be in the insurance industry. It's putting out its own privacy and security requirements. And then one other thing that I'll call out here, obviously I think we are all talking a lot about RPA, the Internet of Things, data analysis, automation, AI. All these are buzzwords right now, and I think these are great tools for organizations to be more efficient with how they use data, how they collect data. You talk about RPA and its ability to streamline business processes. I think all of that is absolutely fantastic, but internal audit should definitely be thinking about asking the questions, is this introducing a new privacy risk? are these new technologies perhaps bringing in new data to our organization that we haven't considered? And even more than that, is it perhaps using data in a way, are we getting to conclusions in a way that we haven't previously let our consumers know about? Are we potentially violating our consent agreements or our notice by using these technologies? This all comes back to the data lifecycle. I think it's important to sort of root any activity, any audit, any assessment to the data lifecycle, and just ensuring that you have an understanding of how data is collected, who's accessing it, how are they using it, where is it being stored, is it being transferred from that storage location, especially off of our network to a third party, and then ultimately, how do you retire that data? And retire, we use that instead of deletion, which I think is sort of the older term, because there's so many more ways that data can be sort of retired at end of life, whether it's anonymizing or pseudonymizing. It's really important to make sure you have an understanding of exactly how that data, is being unlinked from us as personal, us as consumers, and made so that it can't be linked back to a single individual or household. And so what are some of the questions that internal audit teams can start asking? How can you start going to your business leads and your, functional leads and start getting to the root of what data are we collecting and how are we protecting it? So the first one is exactly that. What data are we collecting? Do you have a good understanding of through the website or through a third-party application or however else data might be collected? That, hey, we're actually collecting Social Security numbers, so we need to make sure that's being protected. The next question to think about is, how is that data actually being used? Is it being just used internally? Is it for internal use only? Is it being sent to a third party? Is it being used in some sort of decision-making process? And then how do we tie that back to our consent, our notice, our agreements with third parties? Where is that data being stored? Are you confident that it's only being stored internally? Or is it being shared with a third party? Is it being stored in a cloud solution or only on-prem? Is it structured or unstructured data? You start to think about all of those collaboration sites where data might be stored. I've got a client that uses an internal file share for all of their know your customer inquiries. And so there's a lot of personal information that might be stored on desktops out there. So just having an understanding of where that data is residing is important. How is data being protected within the environment? Touched on this a lot. What encryption protocols are you using? What access management procedures are you using? Are you logging and monitoring access to sensitive data? So become best friends with your information security team. How long is data kept? I'm hoping most organizations have a data retention schedule, that they're following it, that they know that this type of data is being kept for this long. But then the next step is really, are you retaining any of that data that's not even being used? I think that's sort of the follow-on question. We've collected all this data. We thought we were going to use it, but it actually turns out it's sitting unused in a database somewhere or in a data lake somewhere. And so that's a risk to your organization, that it's not data that's important to your business, but you're still holding on to it, and it's still potentially valuable to a malicious actor who might want to exfiltrate that data. And then, can you actually delete data upon request? We're having all kinds of conversations with our clients about actually testing their ability to delete data. Elizabeth alluded to this earlier. Actually running through a tabletop exercise like you would with your incident response program is really important for privacy teams to consider. Taking a request from a consumer, actually walking it through the process of identifying where that consumer's data is being stored, and then actually deleting it and making sure that you've deleted it from all the necessary sources, including, like we mentioned earlier, those offsite storage locations or those third-party hosting solutions, any number of places where data might be stored outside of your control. So with that, we've got about 10 minutes left. I think we're going to turn to a question and answer session here. We want to make sure that we give everyone a chance to sort of ask the pressing questions. I know some have been coming through for the chat. Certainly throw up some conversation starters up here for everyone to consider, but we want to hear from you, and we want to hear what questions you all have.
I believe we've had about 3 come through so far, so we can quickly try and address those. Starting with, we had a question about what about government agencies? So even if you're a nonprofit, would they be covered under Ccpa? So generally under Ccpa, if you look at the definition, that long definition of what a business is, it can be a sole proprietorship, partnership, LLC, corporation, association, or legal entity. And here's the important part here, that is organized or operated for the profit or financial benefit of its shareholders or other owners. So with that definition in mind, it would not include a government or not-for-profit entity.
Right. But obviously that doesn't mean that government agencies don't have their own privacy requirements that they should consider. You know, HIPAA, for example, you think about the NIST's privacy controls that we've talked about. I think Title 13 has some privacy implications as well. So certainly lots of requirements for government agencies to still put a privacy program in place.
Yeah, and it also kind of drives home the importance of that scoping process when you see a new regulation, kind of reading through it, understanding how it applies specifically to your organization.
Stephanie, Katie, did you have some other questions come through on your side?
Hi, this is Katie. Can you guys hear me?
We can.
Okay, great. So let me just pull up the questions here.
I see one other question here. Sorry, Katie, while you're looking, we have customers in all 50 states. Do you see a federal privacy law coming that is consistent across the states? And we talked about this a little bit earlier as well, but we are tracking this. We definitely we haven't seen any significant traction in this area. The most recent updates have been back in November of 2019, where both houses, or both the Republicans and the Democrats, have proposed their own versions, but obviously no traction has been made since that time. So definitely still tracking this, and it's a possibility, but getting everyone to agree on one bill obviously is difficult. So still tracking this.
Yeah, unfortunately, I think we're going to see several more states come online with their own privacy regulations before a federal regulation were to be passed. So I think that's going to be, when you think about organizations that obviously operate across state lines, you even think about just having visitors to your website from you can't restrict that. So tracking the state laws is going to be really important for organizations as they move forward and think about their privacy program. Once again, I'll stress the importance of looking to a framework like NIST or ISO or something built in-house. I think that allows you to instantly get ahead of the game and be more responsive to a privacy regulation. And it's really about just tweaking at that point rather than starting over from scratch.
Interestingly, we've also seen in the news some organizations just say, forget it, we're not going to worry about having different rights for each of the consumers in different states. We're going to take the most stringent, in this case, California right now, and apply those to all of our consumers for ease of application.
Mm-hmm. So guys, I have another question here. Could you go back to slide 38 and elaborate on how this can be done for a mid-6 advertising organization?
Yeah, absolutely. Let me switch back to 38 here. So I think this is slide 38 that we're talking about. Mm-hmm. So I'm not familiar with mid-6. Maybe they mean mid-size advertising organization. So I think there's a couple different approaches that you can take here. I mean, and it's really taking a risk-based approach. Obviously, I think that's perhaps an overused term, but it's really thinking about what data do you actually hold. Is it sensitive data? Is it financial data? You think about advertising firms, having potentially, cookies and web beacons and things like that. And so it's putting the right controls at each layer. Happy to talk, whoever asked this question, happy to talk more offline about some specifics, but trying to keep this sort of applicable to everyone on the line here. But, it's being reasonable, obviously understanding that security and privacy teams have budgets they need to consider, limited resources in-house to implement, a robust DLP program, for example, could be quite pricey. Rolling out a DDoS system across your enterprise could be pricey. And so it's the right mix of tools and technologies. It's the right mix of, manual processes and monitoring, and then, the right partnerships with third parties that can bring that expertise, just-in-time expertise. You think about organizations that provide the ability to respond quickly in the, crisis situations like data breach. So making sure that you've got arrangements with organizations like that that can help you when you need it, and you're not paying for that service full time. Elizabeth, I don't know if you had any other thoughts on that.
The only thing I'd add is that, we've had clients have success performing peer benchmarking assessments. So taking a look at other or their partners or their peers in their same industry and doing a lot of, open source research, or, trying to figure out and compare themselves to other organizations.
Absolutely, yeah.
So another question is, how does Ccpa define California resident?
Yep, so that's a great question. So I think the easiest way that I've been able to find to think about California residents is really comes around to sort of like tax filing status. So if you think about those individuals or families or households that are submitting tax filings in the state of California, that's a pretty good collection of individuals that would be considered in scope. So that's why the example of, this is an example I keep coming back to, but a college student who's going out of state for college, they may be residing in Boston, but because, so their legal residency is California, because that's maybe where their family lives, that's their full-time address, and that would be their, they would be under Ccpa, they would have the same rights as someone who's actually physically in the state.
Great, and we do have someone on the line who's raised their hand, so I'm going to unmute, and that is Carlita Reed. So Carlita, I've unmuted your line. Can you speak? Carlita, are you there?
Yes.
Okay, great. You're unmuted if you want to ask your question.
Oh no, I raised my hand down. I don't have a question. Thank you.
Okay, thanks. Okay. So Kenneth and Elizabeth, it doesn't look like there is any other questions at this time.
Okay. Well, we're almost right at 1:30, so that's perfect timing. Once again, thank you all for attending. I think, like I said in the beginning, it's really great to just sort of come together, as professionals and talk about something that isn't necessarily the pandemic, although we talked about it a couple times. I'll echo the point again. If you have any questions, we'll be sharing the deck out. Our contact information is in there. Feel free to reach out. Elizabeth and I absolutely love this stuff. It's what we're passionate about. We really enjoy this work. So any questions you have, any conversations you want to have around your organization and privacy, how to work privacy into your audit plan, we're more than happy to have that conversation and would actually relish it. So with that, Chris, Marcus, I'll turn it back over to you if you have any closing thoughts or comments.
Yeah, great. Thank you, Elizabeth and Kenneth. A lot of great takeaways on privacy, and as well as thanking Cross Country for partnering with the chapter. As I mentioned before, the CPA certificates will be going out sometime next week. Information will be posted on the chapter's website with the slide decks, as well as we'll be pushing out some notifications on some other of the chapter programs that will be occurring. So, and just finally, thank everybody for attending, and please be safe.
Thank you all.